Hello everyone and welcome back to the Lazy Learners. In today's audio session, we are going to discuss the origin of competition law in Indian competition regime. In order to achieve the objectives of DPSP, that is Directive Principles of State Policy, which is enriched in the Constitution of India, central government took several efforts. The first one was the Constitution of Planning Commission in the year 1950. The second one was Industries Development and Regulation Act of the year 1951. It was enacted for controlling the pattern of investment, either directly or indirectly. Directly through the creation of large public sectors and indirectly through industrial licensing and targeting that affected the private sectors. The third one was Professor Mahalanobis Committee. This committee was set up for checking equality of distribution of wealth and resources. The fourth one was Monopolies Inquiries Committee of the year 1960. This committee was set up to inquire into the extent and effect of concentration of economic powers in private hands and the prevalence of monopolistic and restrictive trade practices in important sectors of economic activities other than agriculture. The fifth one was enactment of MRTP Act 1969. The sixth one was the Expert Group of 1999, which was appointed by Ministry of Commerce on the interaction between trade and competition policy. Among the following, Monopolies and Restrictive Trade Practices Act of the year 1969 is one of the important efforts made by the central government at that time, with the objective to achieve the objectives of DPSP, which is enriched in the Constitution of India. The MRTP Act of the year 1969 was limited in its sweep and hence fails to fulfill the need of a competition law in the age of growing liberalization and globalization. All quantitative restrictions, that is QRs, have been completely phased out and with low-level tariff already negotiated during WTO rounds, that is World Trade Organization rounds, India will be facing severe competition from abroad. In view of this, Raghavan Committee was constituted in the year 1999 to examine the existing competition regulation and to propose a modern legal framework that would into India's transforming economy. Raghavan Committee of the year 1999 recommended to repeal MRTP Act of the year 1969 and replace it with Competition Act of 2002. Till date, amendments have been made to the Competition Act 2002, that is Competition Amendment Act of 2007. Now let us take a quick revision of the origin of competition law in Indian competition regime. The first one was Planning Commission of the year 1950, then after Industries Development and Regulation Act of 1951, then third one was Professor Mahalanobis Committee, then fourth one, Monopolies Inquiries Committee of the year 1916. Then fifth, enactment of MRTP Act 1969. Then sixth, the Expert Group of 1999. Then after there was a Raghavan Committee in the year 1999 which recommended the Competition Act of 2002. Thank you for being stay tuned with us and please subscribe to the channel for more audio lectures. Thank you.